morning. Welcome. Next matter on our docket is docket number Androscoggin 23-149, State of Maine versus Jaquille Coleman. The matter is in order for oral argument here today. And gentlemen, as you know, our practice is to let you stand, identify yourself, the party you represent. But we're now streaming video live, so I'm going to ask you actually to step to the podium so the folks watching can see you rather than be a disjointed face. So first for the appellant.
Thank you, Your Honor. Rory McNamara for Mr. Coleman.
Thank you. And for the appellee.
Assistant Attorney General Donald Macomber for the people of the state of Maine.
Thank you. All right, we are ready to get underway. Mr. McNamara, I'd be happy to hear you on behalf of your client.
Thank you, Your Honor. May it please the court, counselor?
And it looks like you're green-lighted coming through the door, as usual.
Yes, please, yes.
So I want to take you first to the assertion of prosecutorial error in the argument. And as you know, we've had many cases involving prosecutorial error during argument. And there is some black letter law about which statements presumptively, absolutely are error, and that's pretty clear. And some that have been green-lighted for this is okay to say, but it's the stuff in the middle that we need to determine where it falls on that continuum. And I'll have two questions for you ultimately, but the first is to suggest that in looking at whether or not there is in fact prosecutorial error, we need to look at the entire closing arguments in context. And I'll ask you first if you agree with that concept, that we have to look at them in context.
Of course, yes.
And
of both parties, I assume.
both parties, yes, exactly. And what I'd like to draw your attention to is the arguments of defense counsel, the closing argument. And I want to read it. I know you have it probably etched in your memory, but defense counsel says to the jury, "I want to be very clear. We put on no evidence. We put on nothing about who else could have killed her, who else might have shot her. We didn't put that evidence on." That is nuanced. It could suggest that evidence exists that someone else shot the victim, but they didn't put it on because they don't have to. So it leaves that hovering in the air. And then upon rebuttal, prosecutor presumably felt necessary to dispel that notion that there's some evidence somewhere, and did what prosecutors we've approved to do, to list all the evidence that's in the record, and says, "I'll say again, your decision must be based on the evidence. Where is there evidence that anyone shot Natasha?" And it is that last line that is the focus of your argument. But I'll just suggest to you that in that setting, was it improper for the state's attorney to dispel any lingering penumbra that might have been generated by the defense attorney's nuanced statement? There may be evidence, but we didn't put any evidence on. Is that a problem? When you look at it in context, simply beyond that one sentence, isn't that appropriate comment for a prosecutor to address an issue that was floated, nuanced as it was, in the defense's closing argument?
No, Your Honor, and I actually think the context here makes it worse. So defense counsel made an accurate statement of law. We don't have any burden to prove that somebody else did this. Even though I'll add, and this is, I think, really colors the argument too, there was evidence that somebody else was in that car, and the state objected to that evidence, and that evidence was excluded. And there was evidence that that other person made statements that were interpreted as some form of inculpatory
But
statements.
the jury can only look at the evidence before it, and to suggest there was some other evidence here that we couldn't put on, but consider that. I think what I'm concerned with when he says we didn't put that evidence on.
Yeah, and that I don't know if it could have drawn an objection or not, but within the context, when the prosecutor comes back and says, "No, where is that evidence?" When, in fact, defense counsel wanted to offer it, couldn't offer it, and on top of that, doesn't have to offer it. For there to be reasonable doubts, They can be outside of the record, in fact, and to imply and to outright say, where is that evidence? In the context of this framing, we don't have to put any on.
But no one can argue about evidence that isn't in the record, and the state's attorney's statement basically says, here's the evidence, where is there evidence in here that someone else may have shot her?
But that's a really nuanced statement. Nobody can argue about evidence that isn't in the record. You can't add stuff that isn't in the record, but you can certainly say, you know, I wonder, was somebody else in that car? I wonder, did somebody else do this shooting? And I think that's what defense counsel was doing. We don't have any burden to offer that, but those are reasonable doubts, and I think that's where that was. And the way I read it, and certainly the way defense counsel read it at the time, was you're saying, no, there needs to, you being the prosecutor, saying there needs to be some form of evidence here for that to be argued. And it's problematic in two ways. We've had a lot of discussion in recent years about the burden flip cases, starting with Cheney really in 2012. But this particular instance is referring to something that really only the defendant, under the state's theory, only the defendant would have been able to say, no, there was somebody else in that car. So it's implying that he personally needs to get on the stand, and that refers to an older series of cases, really going back to the Supreme Court's decision in Griffin, but this court, earlier iteration back in 1980 with the Libby decision, expanded that doctrine to say, when there is an indirect, even somewhat ambiguous statement that implies that the defendant needed to testify to offer some evidence.
But do you agree that it's okay for the state to say, okay, let's look at the evidence, A, B, C, D, and E. That is the evidence. There's no more evidence beyond that. This is what you're limited to. Is that okay?
The limited part is, I don't think that's okay for a prosecutor to be saying, because you're not limited to what just came in the evidence.
Well, you draw reasonable inferences.
Right. Oh, that, of course, you always have that, and I think that applies to both sides. But a defendant, when you're talking about failure of proof, can say, well, there are doubts that are reasonable to you that weren't presented within that universe of evidence, and that's where maybe you should be focusing your attention. So I think that is the distinction here.
Okay.
And if we look at the nature of this statement, under those two strands of cases that I've been talking about, the Wei Chan decision, it's improper for a prosecutor to say, the idea that somebody else could have done this, well, where's the evidence? I think that this checks off that box there. But also, if we go to the Griffin style of cases, if you will, the Libby case, where the prosecutor is saying, if there's another explanation for this, I would be interested in hearing it. And saying, I think you're entitled to hear from them. Where's that evidence? That kind of thing is improperly implying that a defendant personally needs to get on the stand and offer that testimony.
But in saying, quote, we didn't put that evidence on, isn't defense counsel suggesting that there is other evidence?
Well, and that's, I think, permissible within the scope of, you can argue reasonable doubt that's outside.
Is it permissible to ask the jury to speculate about what that other evidence might have been?
Yes, it is. Speculation is the nature of coming up with reasonable doubts. You're saying, I speculate that there may have been somebody else involved there.
I think we have a jury instruction that suggests that jurors should not speculate on what other evidence might have been presented.
Right. I actually think that violates a defendant's opportunity to argue reasonable doubts. It wasn't raised here in this case. But I also think, let's assume that you're right, that principle could come out of the defense attorney's statement there. The court didn't object. The state didn't object. The state didn't rise when the defendant objected to the rebuttal statements by the prosecutor and say, well, I was doing it in response to that statement. So I think if we're true to the nature of appellate review, it wasn't heard that way by anybody in that courtroom.
Right, but
in that manner.
The prosecutors was responding to the statement about that evidence. Where is that evidence? Is that
I think
appropriate?
it's not appropriate.
Evidence that the defense counsel suggested exists?
And in fact, some of it did exist in the sense of there are statements out there that somebody else was in that car. They didn't get into evidence
But
because the prosecutor.
it was excluded.
Right.
So in a sense, I mean, the defendant is backdooring some suggestion of evidence that the court had specifically excluded.
Well, the prosecutor, excuse me, the defense lawyer is not offering any evidence. He's pointing out the possibility that there may be reasonable doubts in the form of that area over there, over there.
Remind me, was there other evidence in the record that there was a second person in the car outside of what was excluded by the
No,
trial
no,
judge?
Your Honor, there was not. And I do have in a footnote in the blue brief citations to federal cases that say it is also Griffin-style error and therefore inappropriate for a prosecutor to say, well, there is no evidence about items that were excluded because of the prosecutor's objection to that evidence, when in fact that alternative suspect evidence is out there.
But in those cases, did the defense counsel sort of prompt that response?
I don't know the cases well enough to say one way or
Isn't
another.
that the difference here? I mean, here defense counsel sort of prompted that. What could the prosecutor say in rebuttal?
The prosecutor could say, I think you ought to look at the very firm evidence. I'm speaking as a prosecutor here, not as a defense lawyer, as to X and Y and Z.
Do you think that's as far as he can go with it?
Right. I don't think the prosecutor can then say, well, where is the evidence of this alternative suspect theory?
Hey, can I ask you, in the very short time you have remaining, the witness's statement regarding her fear
Yes.
that
Yep.
came in?
Yes.
The state conceded that it was error to admit it, but I want to ask you, in a case like this where it is the parties had a relationship and the jury's looking at the fact that he is charged with killing her, which is not consistent with a relationship that's going well, it's a fulfilling, happy relationship. There was hostility, there was contention, and there was fear on her part. Wouldn't it be admissible to show that she had a fear of him, to show that this relationship had broken down, and that there was hostility and contention?
No, Your Honor, you know this court's Penley decision recently from a year ago or so that said that the decedent's fear of a defendant is
The subjective
generally not
state of mind of
relevant.
the victim is not, but not offering it for the victim's subjective state of mind, but whether or not it would explain, and we keep saying context, the context of how this event occurred.
And I think that treads so carefully on 404B concerns and 403 concerns because it is implying that what happened in terms of the murder charge, the causation of death, is a product of that history, of that relationship behind us. And that is certainly the way that this was utilized in the state's closing argument here, that we know who it was because of this fear, this past.
Thank you, Attorney McNamara. We'll see you again on rebuttal. And Attorney Macomber will be happy to hear from you right now. I almost called you Macomber. And I'm sure that's not something you would have welcomed. So anyway, we're happy to hear you, Attorney Macomber.
Thank you, Justice Meade. May it please the court. And I also want to thank the court for rescheduling this matter at the last minute. My appendix decided it didn't want to part company with me just days before we were supposed to do this last month. As you pointed out, Justice Meade, we did concede on the first issue regarding fear. The only reason I conceded is because of this court's decision in Penley. In Penley, the court said the admission of such evidence was error, but it was harmless. And for the same reasons, I made the same arguments. I cited in Penley, showing why we thought this evidence should have been admissible for the reasons you just pointed out, that it wasn't hearsay because it wasn't offered for the truth. It went to the nature of their relationship falling apart immediately before this murder happened. But the court determined that that was error in Penley, so the question is it harmless error? And for the three reasons I cited in my brief, the error was harmless. First, unlike in Penley, the trial court limited the amount of evidence the state could introduce to just this testimony from the friend about the victim being afraid of Mr. Coleman and that they had developed a safe word. Second, The evidence was harmless because similar evidence came in the testimony of the victim's grandmother that the night before the murder, the victim was shaking in fear when Mr. Coleman was knocking on the door trying to get in to talk to her. And third, the evidence was overwhelming in this case. The victim's mother, who's present in the courtroom today, saw Mr. Coleman shoot her daughter just feet away multiple times. To reach any conclusion other than that Mr. Coleman would have been convicted under any circumstances defies logic. As for the argument issue, to me, it's, as Justice Horton, you, Justice Meade, and Justice Douglas pointed out, this was an invited comment from the defense counsel's argument, arguing from no evidence that someone else may have committed this. And the prosecutor appropriately said, this is the evidence. And then where is the evidence that someone else did this? That's appropriate under this court's decisions in Cheney. It's appropriate after this court's decision just weeks ago in Thistle, where the prosecutor talked about evidence-free assertions. It's appropriate for a prosecutor to point out that there's no evidence to support a defense counsel's argument. And I'd be happy to answer any questions the court may have.
Let me ask about the allocution. Do you think when a defendant allocutes that that's a waiver of their right to remain silent?
I do. It absolutely is. You know, they don't have to allocute. They choose to do it, then it's fair game for the trial court, sentencing court, excuse me, to take stock of the sincerity of that allocution. And that's what happened here.
I quote from a Colorado case that said, there is no constitutional right to be free from a court considering a dissembling sentence allocation. I would assume you agree with that statement?
Absolutely, Your Honor.
As we know, a court can't, in its sentencing analysis, say something to the effect of, this person is remorseless because I didn't hear him say, I have remorse.
Exactly.
But here, looking at the actual language that the defendant teed up during the course of the allocution, started off with something that sounded like remorse. I apologize to those who are affected by the loss of attachment. It sounds like he's headed towards remorse. But then he turns and says, I failed to protect the one person who meant the most to me, which is a sharp turn.
Absolutely.
And I assume you would argue startling under the facts of the case to say a thing like that. So was the judge reacting viscerally, do you think, to say?
I think that's exactly what happened. I think that the sentencing court saw Mr. Coleman say exactly what you just quoted and said, I don't hear, and he said, I don't hear genuine remorse coming from you. And I think that's appropriate for the sentencing court to do.
If it had been a more neutral statement, to me, that sharp turn there is a little jarring. But if he'd made a more neutral statement, just wishing people well, would the court in that situation also be okay to say, I hear nothing sounding like remorse?
I think so. I mean, you know, the sentencing court is in the best position to determine, viewing the defendant while speaking, is what I'm hearing genuine or not? So I think that's exactly what happened here, is that the sentencing court saw.
I understand the appellant's position not to be that the judge erred in determining lack of remorse, but in counting lack of remorse as an aggravating factor as opposed to a mitigating factor. And remorse is
This court has repeatedly
often
said
viewed as a
lack of-
mitigating factor at guilty pleas and so
Right. I think
acceptance of responsibility, et
courts have
cetera.
this court has repeatedly sanctioned the use of lack of remorse as an aggravating factor. That's what happened here, appropriately.
When the court is evaluating that, is the court looking at the facts, as you indicated, the facts here are pretty compelling? Is it appropriate for the court to think and say out loud to the effect of, wow, this case is made in the shade, there's no two ways about it. You, Mr. Defendant, should show remorse. Is that okay?
Comes closer to the line than this one.
Well, we have a situation here where he affirmatively chose to say something.
Exactly.
So you listen to what he says. He has decided to exercise his right to speak, not to remain silent.
Yes.
So again, that's a waiver, isn't it?
It absolutely is a waiver.
But he's essentially maintaining his innocence. That's what it
Well,
amounts to.
He is and he's not, because he says, I'm sorry I didn't protect your daughter. That, to me, is it remorse? It's not remorse. It's the opposite of remorse.
Can I take you back to the closing arguments?
Yes, Your Honor.
Putting aside the fact that this was evidence of the second person in the car was actually excluded here. If I'm sitting in the jury box and I hear the defendant say, we didn't put on any evidence, and then the prosecutor gets up in rebuttal and says, well, where's the evidence? Wouldn't it be reasonable for me to conclude that, well, why didn't the defendant put on any evidence? In other words, is there an implied burden shift here?
I don't think there is, because of the way this went down. The defense counsel suggested that there was someone else in the car, that it was free for the jury to conclude that there was someone else in the car. The prosecutor pointed out, this is the evidence. You must decide the case based on the evidence. Where is the evidence that somebody else did this? Objection at sidebar. Trial court immediately says, the burden's entirely on the state. The defense has to produce nothing. I think that eliminates any suggestion of a burden-shifting issue.
Don't hear any other questions unless you have something further, Mr. Macomber. We
I
thank you
have
for your
nothing
argument.
further other than thank you.
Thank you. Mr. McNamara, back to you for rebuttal.
Elocution briefly, I did want to address one point briefly. The state and I seem to be talking past one another. The shaking component, the fact that the grandmother saw the decedent shaking the night before, that is claimed as part of the error to which the state apparently conceded error. That's on page 13 of the blue brief. Really, all the instances of that are on page 4 through 8 of the blue brief. I think we need to, when discussing the allocution, distinguish between the right to remain silent, which obviously the defendant did waive that. However, and the right not to self-incriminate, that remains, as the Mitchell case makes very clear, on through the end of sentencing. And the two federal cases I cited in the gray brief make clear that it can be violated even though a defendant allocutes. So it's not something you give up just by speaking, and you can rest on that. And certainly by saying I failed to protect somebody in the context where my client feels that somebody else in that car shot the decedent, that to me is, I'm continuing my defense. And certainly the fact that I'm here today litigating this appeal is part of that strategy. It's clear to me that the statement from the trial judge that there was a lack of genuine remorse is a statement that means there was a lack of a statement that I am guilty. Because defendant was remorseful in his other comments, perhaps not excessively so, or not to the judge's standards, whatever. But for the judge to say on top of that, you lack genuine remorse, and then to aggravate the sentence rather than just fail to mitigate it, I think is indicative of the penalty here. To double back briefly on the argument regarding the evidence, the issue of Natasha's fear. Your Honor had mooted the possibility that this was relevant, even though the state has conceded error for the nature of the relationship. However, how is the nature of the relationship relevant in this case? To me, the only way, and certainly the way that it was utilized by the prosecutor, is to say, well, look at this relationship. Of course he did it.
Well, it's to show that the relationship broke down.
I'm sorry?
Why isn't it relevant to show that they're estranged? It broke down.
Well, why is that relevant to, so the state has to prove intentional knowing causation of death of another. To show that there was animosity before time, that's just a propensity inference. It's a continuation of those bad acts from before.
And I see the red light is on.
And talk more, sorry.
And you've addressed it in your brief. We appreciate that. All right, appreciate the briefs and arguments of counsel. Take the matter under advisement, issue a decision in due course, and the court will be in recess.
All rise.